And now I'd like to introduce our speakers. The complete biographies are included with today's PowerPoint. Louis Pietroluongo is an insurance and government relations consultant at Mound Cotton Wollan Greengrass. Lou has 43 years of public service experience at both state and local government. Michael Volkov is CEO and owner of the Volkov Law Group, LLC, and has over 30 years experience in practicing law. He's a former federal prosecutor and veteran white-collar defense attorney. He has expertise in areas of compliance, internal investigations, and enforcement matters. Bernard Woolfley is managing director in the disputes and investigations practice of Navigant, where he provides forensic consulting services to law firms, government agencies, and both public and private companies. So with that, I will turn it over to Michael. Like I said, Michael, are you there?
And Michael's line is disconnected. If you'll wait one more moment.
Okay. Everybody can just pause for a minute. Great. Michael, are you with us?
Yes, I'm with you. Sorry about that.
Excellent. That's not a problem. Over to you now. We've done the introduction, so we can kick it off.
Okay, thank you very much. Appreciate the opportunity with LexisNexis here. I'm having a little bit of a technical glitch, so I'll ask you to switch the slides if somebody can do that as we're going along. First, why are we here, and why are government investigations so significant that we have, a large number of people listening to us for an hour and a half? Well, there's two phenomena that's really occurred in the marketplace right now, and in terms of the importance of government investigations. Number one is we have probably the most aggressive enforcement scheme that's ever occurred. I have to say, I've been in D.C. practicing law for 30 years, and this administration has been probably the most aggressive federal enforcement scheme that I've ever had to deal with in terms of clients. That's number one. Number two, the other thing that is occurring, and the reason why we're going to go into great detail in terms of dealing with the federal probe and how you conduct a federal probe, is that a lot of the investigations that were typically done by the government through the grand jury process or through CID process, civil investigations, are now being outsourced. And they're being outsourced to law firms and defense counsel who represent corporations and who then go ahead and go out and do the investigation themselves. This has become very, very significant in terms of the impact that it's having on the whole criminal justice system and all of the investigative system. And that's why we have to go into detail here, because now what is really critical is how the investigation is conducted and how you interact with the government. And because so much of this is now being outsourced, it's almost like people are becoming, in a sense, arms of the government in terms of doing their internal investigations. And there's a whole sort of set of skills that have become relevant in terms of this process and how we go forward. So there are definitely things we have to look at. And so let's start from the beginning in terms of what I call the imperfect storm. I actually did like the movie The Perfect Storm. But and why government investigations? First off, we all know what happens, and what is your sort of nightmare scenario that can come up for any of your clients or for your company, are obviously operational disasters, media reports, but government requests for information, in other words, rolling investigations, sources of information that lead them to that. We have whistleblowers now. For example, at the SEC, you can recover 10 to 30% of any government recovery. We also have the key TAM relators in False Claims Act cases who are doing the same thing. Everybody's got a financial incentive right now to report misconduct. All you have to do is just put in whistleblower attorney into Google, search it, and you'll see millions and millions of attorneys come up who are basically in this business looking to cash in on some of the big settlements. The other thing that I think we all have to worry about is because of the internet and social media now, a controversy can hit the airwaves or hit the internet in a sense within hours. Target's recent data breach was within hours. It was all over the internet, and all of a sudden there you have what could be a massive investigation and a company that's trying to get, in terms of trying to fix the problem. Again, we always have disgruntled people. There are a lot of disgruntled people who like to start investigations, employees, whatever, that do this. And then we see civil litigation as a big source of sort of government investigations. Look, we're going to talk about a lot of scenarios here. There is no, I always remember from my days as an assistant U.S. attorney, there's no one way to do something. There's no one right way to do something. There are many ways to sort of skin the cat, as they say, but we're going to look at a set of risks that come up in a lot of types of situations. Obviously, FCPA, accounting fraud, antitrust, these are all big things. Environmental violations are huge, and obviously OSHA, believe it or not, has become very active in connection with safety violations. And so every investigation that occurs, what it starts as a government inquiry poses, and we're going to talk about the scenario in sort of the bet your case type of internal investigation. Everybody is, in terms of their compliance program nowadays, has to have some type of internal investigation function. What we're talking about in these cases are the bet your company case where it's something significant. Take the oil disaster, the blowout that occurred in the Gulf, something that's huge where the government and PR and everything is going to come together in a huge mess that you have to deal with. So the risks that we look at are obviously what the government's going to do to you, the litigation risks in terms of civil suits, shareholder suits, derivative suits, competitor suits, obviously victims in an antitrust case are going to sue against a cartel or members of a cartel. Business risks in terms of reputational damage. We have personal risks that we have employees, we have officers, and we have board members who are all at risk for prosecution these days. And obviously we have operational risks. I put reputational risks down at the bottom, but for a lot of companies, that is almost one of the most significant risks that they face. They pay huge fines for certain things, but it is the reputational damage that hurts the most in terms of their ability to operate in the marketplace and to compete against their competitors in that sense. So let's look at the crisis stakeholders. Obviously, we're looking at a situation where a company faces a crisis, where we're talking about setting up what I call a crisis response team, a CRT. And there are crisis stakeholders and there are risks that are facing all around them in the company. So we have collateral litigation, which is shareholder suits and class actions. We have the impact in the stock market, competitors, and financial impact. Interestingly, you know, the day that an FCPA investigation is disclosed, within 2 weeks, you'll probably see 20 to 30 civil suits filed by shareholders, derivative suits against the board, against the company, against managers, everything. And you'll see a 6 to 8% drop in the stock market price of the stock. Now, a lot of times the stock market price goes back up, but at least for a while they're going to suffer some damage, and depending upon the impact that the case has, you're going to have more stock market damage. Public relations and reputational damage. Obviously, the media is a significant source of worry, and you're going to have to be careful of that. You also, in any big case, who's going to get involved? The politicians. And the politicians want to get involved for one reason, publicity, and to get a message across. So you could have sanctions, you could have oversight, you could have an investigation, which is being done parallel to the government investigation and your own internal investigation, which is related to the government investigation. And finally, we have, obviously, government prosecutions. What's interesting in cartel cases, FCPA cases, that the government we're talking about is not just the U.S. government. We're seeing more and more coordinated prosecutions in the FCPA area or the corruption area. And for a long time, what's been going on in terms of cartel enforcement since the 90s are other countries are involved. I'm in one case right now where I'm basically resolving my client's situation with 5 different countries and negotiating settlements in those 5 separate companies. So Company A is sitting there with all of these forces coming at them, and they need to respond in a significant way. They need to respond with the crisis response team. Now, when we say government, obviously I just mentioned the international government, but look at all the different types of, government agencies that are out there. We're not even getting to the state agencies. One thing that's occurred lately, the False Claims Act, for example, a lot of the states have passed their own False Claims Act and are enforcing it through their state attorney general's offices. We see that all across the United States in terms of states are getting into the action as much as they can. We have anti-kickback laws that apply in states that also mirror the federal anti-kickback law that applies in the healthcare industry. We also see, like I said, in the global area, we're seeing more coordination. We're also seeing more and more settlements and investigations that are being done in coordination between the federal agencies and the state agencies, where the states are getting involved, particularly in antitrust, in merger enforcement. We see that. But these are just some of the agencies where investigations can come up. We all know about the U.S. Attorney's Office, the SEC, the FBI getting involved. But there are many other agencies at risk, and just to make life even a little bit more interesting, we even get into the OIG type of investigations, which could have collateral consequences to other companies, not just to the government employees when OIG's officers get involved in these type of things.
Great. Thank you, Michael. Appreciate it. Let me go back for 1 second, just back to that slide that Michael had where we said what we mean by the government. When we take a look at those agencies up there, there's a lot of those groups that focus across a variety of different industries and business sectors, but there's some that are also, quite frankly, very focused. So the DCAA, for example, which is on the 3rd row down, that focuses predominantly with government contractors. The CFTC focuses predominantly on financial conduct and financial transactions. So when you take a look at these organizations, there are some government agencies that are very focused on things, but there's also some government agencies that have a very wide mandate as to the types of scrutiny that they can put on different types of companies and different types of industries. I'd also note that we've left off here some of the many government agencies that focus more on things like safety issues or product issues or things like that. So there's really a wide spread of government agencies, and so it's really hard to imagine a company that wouldn't be subjected to some level of scrutiny by one of those government agencies. And as you take a look at it, I'm told there's over 500 registrants on this call, and so it's obviously safe to say we've got folks across a variety of those industries there and could be exposed to investigations from any one of those entities. But my sense is that for many of the folks on this call who are on, who work at a company, they're probably deep down thinking to themselves, the company that I work for isn't really the type of company that the government investigates. And, this is not surprising. I mean, people generally have the feeling that something like this won't happen to them. But as a practical matter, if you take a look at what's going on, there's some real risks to thinking that way and thinking that it won't actually happen to you. To be very clear, well-run, ethical companies face government scrutiny all the time. Even if a company does everything in its power to control and manage the activities of their employees, it can be really difficult to stop that one employee or manager who takes an action that might help themselves but exposes the entire company to some serious government scrutiny. And sometimes that's all it takes for a government inquiry to start. And, you could also, well-run companies still have situations where disgruntled employees with an axe to grind choose to become a whistleblower. And the facts that they put forth may or may not be accurate for them, but the government may not know that, and so an inquiry may be coming. There may also be just a simple situation that a well-run, well-managed company has an accident at their plant or within their operations that nobody ever foresaw. So any of these things can expose the best of companies to government investigations. And, obviously they're unexpected events, but one of the things that I find always very interesting when I talk with folks at companies on a regular basis spend a lot of time and a lot of money focusing on disaster protocols for their operations, situations about when they would, how they would operate their business in the case of some type of disaster within the business, whether it's a national emergency, a weather event, any of those types of things. And the companies generally have pretty well-established protocols for this, and they actually focus very much on being prepared for those things. The fact is, though, many of these things are pretty low-risk events, and once the plans are prepared, they sit up on a shelf and collect dust for a number of times until they're actually needed. But as a practical matter, I sit with a lot of companies on a regular basis who say, gee, I never expected that we would be the subject of a government inquiry, and they sort of don't have a plan for what they're doing. So in my opinion, when you take a look at this, every company out there, in the same way that they prepared disaster protocols for their operations, should be preparing protocols for how their company will respond to some type of government inquiry. And I believe that that type of preparedness has several benefits. Obviously, when it comes to actually having an investigation, and they'll be much faster to respond. They can do it more comprehensively. And that may help limit the actual scope or the components of the investigation. So it's very important, I think, that a company really spends some time starting to put together protocols there. And we're going to talk a bit about a couple of the areas that I think are important. But, obviously when you're doing this, there's the cost-benefit component. I totally understand that with every effort to be prepared comes a cost. And every company will have to make sort of a different decision based upon cost-benefit as to what they're most comfortable with in preparing for investigations. Some companies that work in very highly regulated industries might very well feel that there's a high likelihood that they're going to be the subject to a government inquiry at some point. And so for them, there's some real value to doing the preparedness and training and being ready to go with a set of protocols should something come up. Whereas other companies may feel there's a lower risk to it and may want to do some things that are a little less comprehensive and obviously would then have a little bit less cost. But to me, there's sort of three things that you can do that are really cost effective that a company can undertake. But I also think that not only does it prepare them for a possible government inquiry, it also puts them in a position where they're actually are implementing some good general business practices. And so the three areas that I think they really should focus on is actually having a plan, knowing their data, and knowing their resources. And so if we move to the first of actually having a plan, I think that an important thing for a company to do is to develop a formal response plan now. Now, I'm not suggesting this has got to be some very detailed, comprehensive document that's very formal or anything along those lines. It's more about getting folks in the proper mindset. A company should be developing a good working group of individuals who could be the team, that core team that helps respond to a government inquiry when it in fact happens. And you see on the slide we've included some folks from different departments that might be helpful here. The legal department obviously would be a key stakeholder in this and would probably be leading a large part of this. But folks from internal audit, folks from the compliance department, those folks would also play a role. And given the nature of the way information is stored today, I think that your preparedness plan has to also have a component there to include folks from the IT team. Finally, I'd also suggest you should be including some individuals from legacy companies and divisions. There's a lot of situations where people acquire a company, and then that company takes several years to fully become consumed by the company that has acquired it. And so during those years, you can find situations where different policies and procedures exist within one subsidiary versus another. So I think those are all very important. Now, when I talk about creating this working group, to me, one of the most important things is to just have correspondence among that group so that, folks have a general understanding of the types of responsibilities that they might have in the case of responding to a government inquiry. I always think it's a real concern when, after a government request comes in, the legal department and folks from IT are meeting from the first time and sort of introducing themselves. That, to me, is not really a best practice. When you take a look at it, from my perspective, I think that you ought to have a team there that has worked together and understands how each of them play a role, so that when a situation comes up and you have to make a response, you really already have some defined roles and responsibilities. Obviously, you're also going to have to develop and determine who that leader is going to be. Because you don't know the nature of the government inquiry, I'd propose that a company should probably have in mind several folks who could play that leader role. You may have a situation where, one of the leaders is, in the area that is in fact the subject of the inquiry and may not be a good person to be that overall leader for the company's response. And so, in those situations, you'd want to fall back to your secondary leader and that second person who could possibly do it. Obviously, as we mentioned in the bottom bullet, it's very important to have legal counsel, spend some time thinking now about the types of documents and data for which type of privilege or special protection might be obtained. There's a lot of cases for companies these days where, there are different types of documents that a company might want to afford a greater degree of protection. And I think those general discussions should occur on the front end now before the inquiry is made. And maybe it's trade secret or customer data, or maybe it's just a simple situation that your data has numerous personal identifiers embedded within it. Talking among the working group about how they would respond to requests for that information can be very helpful, because you won't be starting from the square one when that actually happens. So the next item is knowing your data, and that sort of plays off what I just spoke about. A company has to know its data, and it has to know how long it takes to collect it. And that's the type of thing that the government is going to expect during the initial meetings. Companies are oftentimes going to receive standard requests from the government for standard corporate documents, things like policies and procedures and training manuals and things like that. Having the company actually have somebody who is the designated holder of that information, or at least of a copy of that information, is a very good practice, because it allows you to have a single source from which you can collect this information. Now, you need to make sure that information stays updated and it stays correctly organized in the same way that your actual operating units are using the information. But I also think that if you're doing that, you have this opportunity to make sure that all of your organizational policies and procedures are being updated on a periodic basis and are being done consistently. I think that's something that when the government comes in and looks and they find that, in 5 of the different areas that they're looking at, 4 of the areas have current policies and procedures, and 1 of the areas has policies and procedures that haven't been updated in 5 or 6 years, I think that you're going to find the government focusing very much on that 5th area, because to them it appears that there may not be a situation where there's been as much ongoing supervision and review of that area. So I think there's also an important component here on document retention procedures. Obviously, most companies have document retention procedures, but the notion of reviewing them frequently and testing them periodically is not something that we see a lot of companies do. The reality is, in this day and age, as we sit here and take a look at the electronic data, the fact is the cost to retain information is usually just the cost of some small expansion in your storage capacity. However, the cost to actually cull out old data that you don't need anymore can be much more costly, because it's a human cost of actually going by custodian or by file to determine what is old data and what isn't. So I think, generally speaking, this is something that the working group really needs to focus on and make sure that it has a handle on what the data is and how long it can take to collect it. Finally, I think this last item is one that I think a lot of companies don't really think about, but it's knowing your resources. The reality is most companies go about their normal day-to-day operations already having identified counsel that they're going to work with. on a day-to-day basis on the operations of the company. They may already have accountants in place to audit their books and records, and they may already have certain types of experts in place to assist them on a sort of ongoing basis. In the event of a government investigation, especially one that's significant, you find a situation where you may need a different type of outside counsel. You may need a different type of accountant. You might need an expert on industry practice. And while I'm not suggesting these are groups that you should have, retained on a regular basis, spending the time now to learn about two or three different groups that might be helpful to you, and understanding who they are and developing some relationships with those outside counsel firms is a helpful thing, because when the inquiry starts, you'll then sort of already have a pre-selected group of folks that you're then going to consider against what you now know to be the specific inquiry of the government. And I think that's an important component to this, is making sure that you have enough connection points into the outside business community to make sure that when you need those extra resources, you at least have an idea as to where to start. I think that's particularly true on experts on industry practices. One of the things that is a common response that a company has when a government inquiry comes in is oftentimes to say that whatever they're doing and the conduct that might be at issue is a standard industry practice. That, though, is probably a hard case to make by somebody internal to the company. You're usually going to need an external expert for that type of information. And if you take a look at some of the queries that have come from the government in the last few years, one of the things they focused on is doing industry-wide sweeps, where all of the participants in a given industry receive a specific set of requests at the same time. And so you have everybody within your industry experiencing the same need for a specific type of expertise, perhaps industry practice expertise or something along those lines. And I think if you're the company that really wants to be prepared, you want to sort of know what your resources are out there so that when this happens, if it happens, you're in a position to quickly reach out to the folks that you've already established some small relationship with, even if it's been nothing more than a couple of phone calls, so that you can move forward a little faster. Because I don't think in these situations you're helped by being the last player within your industry to have retained, some type of outside expert or outside counsel. So I think with that, I'm going to turn it back to Michael, who is going to talk more about the initial response to the government inquiry.
Thank you, Bernie, and appreciate the comments. And I think just to reiterate Bernie's points about being ready in advance, I know that people don't like to think about that in advance, but I've actually worked with companies and written about how you should prepare in advance for the execution of a search warrant. If the government shows up and wants to seize documents or whatever, those are types of things that you have to be ready for. So having protocols in place, I know it's a pain to do it in a vacuum, but it nonetheless is worthwhile to do it. So let's talk about a government inquiry, and we're going to get to the types of inquiries because I think there's some interest. Obviously, we have viewers who are from state agencies, and we also have people who are in positions responding to state agencies, and we're going to talk about how you deal with prosecutors or enforcement authorities in general. But first, internally, when you face a crisis response, a situation like this, where you are worried about exposure and there is a public type of investigation going on, obviously the board of directors has to be called into place right away. So your step one is always to notify your board and the board to inform them and to let them know what is going on. And this should be done to all directors, internally and externally. There should be some notification that is done, independent board members as well as, board members who, let's say, are senior executives or the CEO. So obviously, we're going to tell the board everything that we know, and we're going to provide key documents. If, for example, there was a subpoena that was served, if there was a search warrant that was executed, if there was a letter that came in requesting information, Those types of things are going to be important for us to get a handle on, and the board has to be informed. The board is going to be ultimately at risk here and directing this whole sort of response by the company. Number two, the board has to set up an oversight structure. At the height of the board, they've got to decide how they're going to manage this investigation or manage this matter. And a lot of times what they'll do is they'll have a special committee that's set up of board members to oversee this and then deal with sort of the senior leaders on a day-to-day basis, or they may assign it to a particular committee. Let's say the audit committee often gets the responsibility for dealing with these things because obviously in most cases they're responsible for compliance. If there's a financial element to this, again, we're going to talk about that as well. It's got to go through to the audit committee as well. So, and the board establishes this oversight structure in terms of the board members. They're going to direct the hiring of outside counsel, which Bernie described, and the role of management in the investigation. And they're obviously going to maintain, a complete sort of monitoring type role with regular reports. The step 3 that we go to is to establish the senior management crisis response team. This will bring into place the entities that Bernie cited, and this should be done with really a small group in mind, but the key players, so that things can be done quickly and things with not a lot of sort of wasted, spinning of wheels. Things that got to get decided and done quickly, and they've got to get pushed through as quickly as they can. These are really type, an emergency type situation where the company needs to do that. So how does the board oversight work? There are, like I said, there's several, alternatives that you have. Some companies in some situations have, hired and created a special committee consisting of 3 outsiders with, big names and whatever who come in, and let's say that special committee will oversee everything and report directly to the board or to a board committee. Obviously, there should be some type of resolution, in terms of the responsibilities of the committee, the authority, the committee, a special committee is set up. You're going to have a resolution and a charter that's going to set up and give them the authority for what they need to do and what their reporting relationship is going to be. Look, there are pros and cons of the special committee. Number one is it brings in your very sort of high-level people. It gives you the ability to say that this is being done with a lot of independence without any bias. But you also, the con of it is that you do lose a little bit of the control. And it's good for the board to be involved and engaged in this because these are big issues that they have to deal with. A lot of times, in most cases, the board will hire its own lawyers. I've even seen cases where board members get their own lawyers. But usually the committee itself or the board will have a separate counsel from whoever is conducting, let's say, the internal investigation. And this is done to make sure that there's proper oversight, that things are being reviewed. The government is so aggressive right now, at least in the federal government, that they truly want to go after a board member, just like they want to make sure that if the board is aware of something and they don't do something to stop it, they want to find the perfect example of somebody to prosecute and send the right message. Nobody is off limits in this administration in terms of prosecutions, and everything is being done with the purpose of sending a message in terms of how businesses are supposed to operate. Then, like I said, we have our crisis response team. It's important, like I said, to keep it to a minimum level of players. You want to have these people, senior managers, you want to have a compliance person, you want to have an in-house legal person, obviously, the general counsel usually, the CFO, HR, PR is going to be, public relations is very important, and the key is your IT people. As we all know, they hold the key to a lot of information, but your IT people are critical. Along the way, you're going to have to make sure you preserve the attorney-client privilege. Let me tell you how a scenario can sort of break apart. There are cases in New York which have held that, for example, discussions with a PR person about how to respond to something or the impact that this will have or whatever is not necessarily privileged. And you've got to make sure that that's the last thing you need to be discoverable are those conversations. So you have to make sure that this is done in the context of providing advice. You have to document this. You have to make sure attorneys are there. And you have to make sure that this is done with the attorney-client privilege as much as you can. I always say use the Get Smart cone of silence, which shows my age, but I used to love that show. But you got to use very good controls in terms of how you communicate and how you talk to each other and how you document things. Lawyers, unfortunately, for everybody, but fortunate for me as a lawyer, we've got to be involved. So that's the thing that we bring of value to the table besides our advice is hopefully the quality of our advice is the attorney-client privilege. We're going to also make sure that we preserve as much of the confidentiality. The last thing we need to do is lose, trade secrets, IP, anything like that that can come up in a situation like this. Look at the Target situation right now with data breach. This is a classic scenario where you've got to maintain confidentiality, but yet you've got to disclose things to the government and work with the government in terms of how you're going to get this done. So I look at this structure and how you do something. This obviously, anybody, and there's a big assumption here, anybody that is remotely involved or maybe a witness or maybe part of the investigation situation, you have got to make sure they're not part of this team and this effort. They are walled off. They are not made a part of anything. If your general counsel is alleged to have been involved in something or may have been involved in something, that person is walled off. They cannot be involved in this. They have a conflict. You're going to make sure that if your CEO, there are allegations about your CEO cannot be involved. Everybody is walled off until they're cleared. That's the way it has to work, and that's a complication that comes up, and people don't pay enough attention to it. People come in and out who have conflicts, and that can undermine the integrity of whatever you do and your investigation. So please be very, very careful about that in terms of who you bring into the team, who is privy to information, and who is going to be involved. You're also going to look in terms of outside counsel, which we'll talk about. In a lot of these cases, forensic auditors are absolutely critical. People like Bernie provide absolute critical services that are needed and are part of the team. And they are hired usually under the cloak of attorney-client privilege. In other words, they're hired by your outside counsel, for example, to provide information to them for purposes of providing advice. That protects Bernie and his team of the forensic auditors or whatever it may be, safety engineers, consultants, whatever that are needed. All of that is done under the umbrella of the outside counsel to protect your privilege. At the same time, you're going to bring in a remediation specialist. If you have a problem, you're going to have to remediate. The sooner you do that, the better, and you bring that person in as soon as you can into the team approach here and make sure that they're part of this entire sort of reporting and structure that has to be set up. Now, in terms of initial responses and what the CRT has to do, the crisis response team, you've notified your board of this situation. The board is aware of it and organizing themselves. You've created your CRT. You've got to make sure that whatever let's say the disaster, the conduct that occurred has stopped. That's number one. Obviously, you can't have oil pouring into the Gulf of Mexico without having to do something to stop it or trying to stop it. And you have to make sure the conduct is stopping as quickly as you can. Public statements are absolutely critical. Public statements have to be coordinated and they have to be accurate. And right now, for example, BP has several executives who are being criminally prosecuted right now for providing false information, or what the government believes is false information with regard to the rate at which oil was flowing into the Gulf of Mexico. These public statements have to be carefully calibrated. These were statements given to Congress. These were made public. And it turns out they're now subject to being prosecuted. The officials are being prosecuted for false statements to Congress. So that has to be done. All of this coordinated strategic response everybody has to look at in terms of, if you're going to acknowledge something publicly, obviously, and say, well, yes, we are at fault, then obviously that's going to have impacts on your internal investigation. It's going to have an impact on your stakeholders. Everybody's looking to sue you, your shareholders, everybody. And you're going to have to develop a coordinated strategy. This is no easy feat when you have so many forces coming at you at the same time. You'll look for your allies and opponents. You know who's going to go after you. You know who's going to use this information, but you're also going to look for people who are going to support you. Politicians may support you if you have a lot of jobs in their state. Politicians, however, are going to stick their finger in the wind and decide whether or not it's publicly feasible or not for them to do that. So in any event, that is one thing to do in terms of putting together your initial responses, making sure that you're going to have a coordinated team and a coordinated approach as you work through this. Outside counsel, well, this gets into, there's a little bit of a tricky issue here and a balancing that has to be done. You need an outside law firm because obviously you're not going to be able to do this internally. You have, let's say, lawyers involved in this, or your legal staff isn't involved in this, and you need somebody who has a relationship, let's say, with the government or the agency that you're dealing with. So the law firm, you look for law firms that have the experience and obviously the relationships that may be able to help you. But that's a two-edged sword sometimes, and you have to be very careful with regard to the relationships, because you want that counsel to serve your interests. And there is some growing concern that I've noticed that sometimes counsel, even though they're under an ethical obligation to zealously represent that person or that company, the relationships are important. This is sort of an understood thing, and they don't want to necessarily rock the boat with the government representatives, but they make a lot of money off of representing companies before this group. You got to be careful with this and make sure you screen that issue. But the other issue that comes out that's very, in terms of balancing, is the issue of whether you use a counsel who knows your company and has done work for you in the past. There is obviously an efficiency to, if, for example, you're going to use a firm that knows how you're organized, where you keep documents, and how you put things together. That's an important point. That's a benefit. That's going to save you money, and it means you can get your hands on important information and move this investigation along quickly. On the other hand, you have to balance that. Do they have a conflict? The government may very well say, we don't want that person in there. We want somebody independent that we know and we trust, somebody who's a straight shooter, somebody who's known for doing that. Usually they're former prosecutors. Usually they're former Department of Justice officials or things like that. So you have to be careful about this issue, and it's something that is going to be part of the calculus early on. It's going to have to be somebody that you trust, but nonetheless also brings independence, and that you trust enough and have enough of a relationship to say that you do trust. So how are you going to do that? A lot of times the decision gets made by the severity of the allegations. If it's severe and it's a real threat to the company, it may be that you need an independent counsel, somebody who is just viewed as a straight shooter who's going to come in and call it like they see it. So you're going to have to do this sort of balancing process. And a lot of times the independence is critical, and they're going to have the ability to go before state agencies and everything like that in terms of how they're going to present you and represent you, and nonetheless aggressively pursue issues, but without rocking the boat too bad. So let's look at the sources of information and then in terms of how you respond. A lot of times, your response is going to be dictated by the type of, way that the investigation starts and the information that you get early on. So, for example, if there are press reports about something and you don't know that the government, for example, has picked it up and is starting to go after it, and you're fearful of that in the next week or so, let's say, that there have been, let's say, an expose. For example, take the Walmart example in the New York Times when, in terms of their corruption activities that were occurring in Mexico. Once that article hit the paper, you knew that this was going to turn into a tumultuous event, and so you have to go out and plan for just a massive crisis response in that situation. But a lot of times you can also have situations where you have a whistleblower, and whistleblowers or a disgruntled employee, somebody's passed up for a promotion, they file a lawsuit, and they go to the government just because they're upset. In those situations, you have to be careful in terms of and calibrate how you're going to respond. You can't over-respond because then you start to look like, oh, well, this person's actually very truthful. What has struck me in this administration is that they're willing to open investigations based upon uncorroborated statements made by a whistleblower. I've been involved in at least 2 serious investigations when at the end of it, after the company had spent $25 million in legal bills, they found out that the whistleblower's comments or whistleblower's assertions were completely uncorroborated and untruthful. There was nothing to back it up. There has to be some more screening in terms of making sure that what is being provided is reliable, but nonetheless, you have to calculate the risk that the government will take those whistleblower allegations and open a massive investigation. What has occurred now in Washington is that there's sharing of cooperating witnesses from, let's say, other white-collar cases. Now we see people being shared in terms of their cooperation and their information across agencies and across other types of circumstances. So, for example, you can have a cooperating witness who's trying to, get out of trouble, and in an antitrust cartel case, and all of a sudden the second question that's always asked in those debriefings by the prosecutors is, do you know anything about bribery as well, foreign bribery? And that's how these things tend to move around. So there's much more intelligence sharing among government agencies than there was before, and sharing of particular witnesses. And you have to obviously, if you have a cooperating witness who started this investigation or you suspect that they're involved, you have to investigate them. Why are they cooperating? What's their motive? And obviously, do they have any history of lying, or what is, reputation for truth-telling or non-truth-telling? Bernie mentioned industry sweeps, which have been occurring particularly in the FCPA context. Johnson & Johnson, for example, provided detailed information about competitors, which has led to a huge sweep in the pharmaceutical and medical device industries. Sometimes the government obviously will, based upon suspicions and intelligence, will wire people up. They'll record telephone calls. All you have to do is look at the insider trading cases. Those were made through wired up conversations where cooperating witnesses wearing a wire, ambush interviews where they're waiting for people at 7 in the morning at their house, start to talk to them and get information, or recording telephone calls. Those are obvious things. One of the things the government wants to do more than anything in a white-collar case right now is a wiretap case. And in the FCPA context, they're clearly looking for that. Another way that this comes to mind to a company's attention is usually through internal auditors. Internal auditors will find something that looks fishy, they'll pursue it, and then all of a sudden you're looking at an internal investigation. Now, that is not known publicly. That is not necessarily disclosed at that time. but it certainly puts a lot of thinking of what we're talking about here on the radar screen for how you're going to deal with it and whether or not you even disclose it to the government, which is another sort of webinar that can be done unto itself. So based upon at every step of the way as you're in this investigation process, you're always assessing what is going on and how your strategy is working and is it in responding to it or not. So, for example, you want to know what evidence does the government have? Who are their sources of information? If you receive a document subpoena of some sort, the subpoena is critical in providing invaluable intelligence in terms of this. You need to it'll tell you what their focus is. You can look at the documents. You can see the allegations. You look for what I call singular sources. In other words, something that nobody else could know except for one person or one entity. So look for singular sources and start to identify it. If that source is identified, then if you turn out it's a competitor or an employee, you want to get everything that they can do, everything that you can get about that person. If a search warrant is executed at your company, then you've got to go and look for the affidavit that was filed by the law enforcement in support of the search warrant. Oftentimes it's placed under seal, but sometimes the government makes a mistake and doesn't put it under seal, and you can get access to it. If you do, it's absolutely valuable to get something like that. Okay, so now we're going to talk about how you deal with the government, and I know we have a lot of state agencies and state representatives on here, and I will tell you, and I hope that they are going to support me in sort of one of the approaches that I urge here in terms of dealing with the government. Dealing with the government is not as hard as everybody thinks. They're not as, I was a prosecutor for 20 years. I sat across the table from many companies, and I know in terms of how you're going to deal with this, and with them, you have to remember this. They're just like you and me. They're just like, they have the same worries about their families, their children, whatever. They're trying to do their job, usually with not enough resources, and usually with working very, very hard, but they believe in what they do. They're very committed to their job. And my feeling is, because I've been in that position, I also know what they're interested in. I know how they work, what they're trying to accomplish, and how best to deal with them. So one of the things that I would urge people to do is to create a positive relationship with the state agency people, the prosecutors, whatever. But you make your initial contacts. You always treat them with respect. You always treat them in a professional way, but you do not just cave. You also maintain your professionalism, and you respectfully disagree or preserve your client's position. There's no need to ever get angry in these types of situations. Most people are going to deal with you above board. It doesn't help to get angry. It works better if you are firm but aggressive but professional at all times. So every contact that you have with the government provides you information about the case. There's valuable information. I will ask a lot of questions, and I'll say, what's this case about? And I want the prosecutors to talk. I want them to feel that they can be honest with me, and I will be an honest broker with them. There are a lot of things that they will not tell me, and I know that. But, you know, the worst that happens is they say, I'm not going to tell you that, okay? So honesty and integrity and being forthright, not selling your client out, that's not what I'm saying, but being, you know, honest and negotiating in good faith. And if you say you're going to deliver something, you say you're going to make a deal on something, then stick to your deal. I'm not talking about just the resolution. There are a lot of steps along the way in terms of usually what happens is there's a formal start to the investigation by a grand jury. Subpoena comes your way. And the first thing you have to do is say, look, we're going to do an investigation. We don't want to have to produce all these documents for you. Can you at least hold off as we're progressing, and we'll report to you and report back to you. But every interaction gives you intelligence in terms of what you think they're up to, who you think is involved. There's valuable information you can get from your state agency folks as well. If you know how they're organized and how they do their cases, ask them questions and deal in a professional manner. If there is government overreaching and you think that that's not fair, you should tell them, but do it in a respectful way. So don't just sit there and take it, but also don't be a jerk in terms of how you deal. And you can write that down on a PowerPoint. Don't be a jerk. And your initial meeting is always to preserve options. You want to limit the scope of an investigation, and you want to minimize the damage to the company. So in any event, for example, if you have problems at, let's say, one of your plants, and you have 10 plants in the area, you want to try to limit the investigation to that one plant. You don't want the government to say to you, okay, listen, I want you to go look at all 10 plants because you've had a problem at one, and I want you to look at all 10. In terms of you're almost negotiating the scope of your internal investigation right off the bat. And there's always a push-pull here, or pushing back and forth that goes on when you're talking about the scope of the investigation. You have to use as much as you can to sort of persuade the government, let's start with just something here that's tangible, we'll report back the results to you, and we don't want to end up tearing our company apart yet. That doesn't make sense at this point. You want to describe your compliance program off the bat. You always want to say we've had a compliance program, and hopefully you do, but you want to make sure they're aware of it, and you want to have a baseline from which you're going to remediate, but you also, they're used to this presentation, and to be honest with you, they're a little cynical about it because you wouldn't be having the problem if you had a really effective compliance program. That's the way they think. But that's not just always the way to handle it. But don't ever give up the argument about whether or not your compliance program is effective or not. Your internal investigation now is absolutely vital, and you have to set it up in a very independent way to hold off the government from executing grand jury subpoenas or having people come in and talk to them. They are going to only hold off and will hold it in abeyance as long as you are being helpful and you are making firm commitments and that you are setting out deadlines and timelines for when things are going to be done. And you want to always demonstrate your commitment to investigate and remediate. You can say that. We're going to investigate. The board has directed us to investigate, and we're going to find whatever problems there are. We're going to bring them back to you. We're going to remediate these problems to the extent we have them, and always set out the steps you're going to take. Different government agencies, different state agencies will get more involved in terms of the micromanaging of the investigation, but nonetheless, you've got to be prepared to sort of report to these folks and bring them on board to show that you're doing what really has to be done. And obviously, the more I would keep in contact with the government as much as you can, the more contact you have with them, the more that they see you're a believable person, that you're the face for the company, that you are somebody that they can trust. And if you lose the ability to be like if you're not viewed as truthful, you're going to really hurt the company and an honest broker. If they view you in any way as suspicious and holding back information, then you're going to have trouble. And I can't emphasize that enough. I've been in too many cases where I was on the government side where we didn't trust the lawyer, and when you don't trust the lawyer, we made life hell for the company, and ultimately that lawyer gets phased out somewhat by the client. They start to realize it after a while. So you have to do that, and a number of very important points in the beginning is you don't overpromise. You don't overpromise what you're going to do. You're going to say, we're going to go where the facts lead us, that type of thing, because you don't know yet. And you're going to provide the government with the necessary information. You do not promise ever, you do not promise and do not say up front you're ever going to waive the attorney-client privilege. That is a canard. It's a red herring. Whatever phrase you want to use, do not get into a discussion of that. That is just an issue that you can't get into until it may be raised, and we'll talk about that a little bit later in terms of how it can come up. But in the beginning, do not promise a waiver of the attorney-client privilege. Some other things is that the government, has gotten very good at this. Prosecutors are very good at doing this. State agencies, state prosecutors are all very good at this. They know this is their bread and butter. They've got a lot of work or a lot of pressure on them to perform and to produce. So they're used to very complex, let's say, discovery issues. They're used to cross-border issues. They're, electronic discovery issues and how you search for documents, where you search for them. They have capabilities now in the fraud section, for example, to analyze a lot of information at one time. They have access to experts, their own experts. The FBI has a fair amount of resources these days in the white-collar area, for example. So you're going to get, your evidence is going to get tested. And they will test what you present to them, and they're going to have the ability to sort of backstop and see if there is corroboration for that. So the other thing that has occurred because of the globalization of law enforcement and internal investigations, there's a greater degree of cooperation, particularly in the antitrust and the FCPA areas. You'll notice every press release that where the government announces a settlement, they give thanks to the Office of International Affairs. And the Office of International Affairs is a group of lawyers, fairly significant, substantial sized office in the Department of Justice that coordinates all interactions with foreign law enforcement and using treaties and whatnot, and getting discovery, getting documents, and et cetera. So this is a greater phenomenon right now. So don't ever think that just because a document is overseas that it's not relevant. That is absolutely not true. There obviously are rules about you don't bring a document into the United States because then it becomes subject to a grand jury subpoena. But the fact is, when you're cooperating and if you're trying to do your own internal investigation, a lot of times you're going to bring those documents in and voluntarily produce those to them or to the government. Well, I know I've gone on for a little while here, and I want to turn it over to Lou, who is going to talk to you now about on some tips on how you perform the actual internal investigation itself. Lou?
Thank you, Michael. The tips on performing the internal investigation, quite frankly, begins with the practical application of all of the information you've learned in slides 1 through 27. It's important to know up front that no two investigations are the same, and you should expect surprises. These are fluid kinds of issues that occur, and that as you work through the investigation, you have to realize that you may be heading in one direction and may have to change pretty quickly. And that's why all of the information you received up till slide 27, including the groups of people you'll be working with, the teams of folks, the attorneys, and all come into play. Internal investigation should be charged with determining who, what, where, when, how, why. All of that will help you determine the pace, the structure, and the content of how you go about performing the actual investigation. In doing so, you're going to be looking at the number of persons or business units involved in the conduct, whether or not the length of time that the misconduct allegedly occurred, the extent to which employees, mid-level or senior management were involved. So each one of these things brings with it new information that you should have before you actually sit down and begin to conduct the internal investigation. One of the things that we just learned from Michael, and it's absolutely true, is that the government is getting much better at its job. They have more information. You only have to read the news to understand how much information is being passed through the government, how much they collect, how much they look at, and what they're looking at. So in looking at these things, I enter any kind of investigation that I would be conducting with the advisory that the government just probably knows more than you're telling them. What you have to understand is, before you begin to investigate or conduct an interview of any one of your employees, who initiated the investigation? What government entity? What might be the credibility of the information received? Could this be part of a larger ongoing investigation? And I think that was mentioned before, an industry sweep. If it is, it's good to find out who in the industry was investigated prior to your receiving the information. It's always good to know if you were the last person or the last entity to receive the information, simply because with each interview, the government learns more and more about the industry and the dealings within the industry. The notifications to all relevant parties is especially critical, and that was brought up before. Unfortunately, sometimes, as I said, these are fluid, and you may not know who all the relevant parties are. And that also came up in the context of setting up your response team. Make sure that the folks in your response team are not included or might be included in any investigation going forward. Independence, certainly honest brokers, reputation, integrity, having served 43 years in public service, 10 of those years with the New York State Insurance Department, I can tell you that you need to get these folks involved early on so that they can meet with the regulators or the prosecutors or the folks in the federal government who are reviewing the issue. And that first meeting is critical. And it's true. The folks who are doing this, they love their job, and they're going to do their job honestly, and they expect that you're going to be dealing honestly with them. Buy time to build and implement response if this is available to you, but don't stonewall. Don't try to make excuses that the information is not available or that it'll take some additional time, because quite frankly, the folks you're dealing with may already know that, and they have learned that, again, as I mentioned before, from dealing with other entities. And it was brought up before that with respect to the IT, you should know all of the forms, how long it takes to get the forms, who's the responsible person. Cooperation with prosecutors protects you from congressional inquiry and pressure and immediate civil litigation. Yeah, hopefully that's the case, but it's not a bar to further action. It puts you on the right foot. It gets you on the right road to ensuring that your investigation is complete and accurate, and the folks doing the investigation for the government understand that. Purpose is determine the nature and extent of any violation to fix problems. Has the problem stopped? In some cases, we can stop the problem going forward, but it's going to be the internal investigations, the internal investigator's responsibility to identify all of the violations and problems that might be in the mix that require fixing. All parties conducting the investigation must be willing to recommend change from top to bottom. Absolutely. The government, when they come in and look, they're not going to look to see for someone to protect a guilty person or someone who didn't do their job correctly. So that's a must in any investigation, and when that first meeting is critical in letting the regulator or the federal government folks know exactly that you're going to be doing that. Independence is critical to the investigation team, and the charter must be unfettered and focused. Absolutely true that independence, you cannot allow interference once the investigation or the interrogations or the interviews begin. I've often used the story of once upon a time, and at the end of the day, the wolf ate Little Red Riding Hood, or she didn't. You're there to gather facts, to put together the best possible case you can, to ensure that the entity you're protecting or the entity you work for is protected, and the government understands that you're doing all you can. Access to board committee must be restricted. that's something that it's basic to anything, any investigation of this kind. If it's unrestricted, you'll know, and the board will know that they're getting unfiltered, unfettered information. With respect to the subjects of the investigation must be walled off. That's absolutely true if it's possible. Unfortunately, in some cases, as I mentioned before, you will not know who the subjects of the investigation are. And the attempts to limit or frustrate internal investigations will result in disaster. DOJ, SEC will intervene, and the company can be seriously jeopardized. Some of the things that, the DOJ will get involved with the nature, seriousness of the offense, the pervasiveness of wrongdoing with the corporation's history, the nature of the conduct, the extent of harm caused by the misconduct. So these are all things that DOJ and the SEC will be looking at. So as an investigator doing the internal investigation, you have to ensure that you've protected all that you can and understand that these are the issues, the questions that they will probably be posing. So you should be including that in your interviews and in your preparation for any final reports. Report often to the board and more often to select and special committees. That was mentioned earlier with respect to the pros and cons of these special committees. Use your CRT when needed to accomplish the tasks. They're absolutely critical, especially before you begin your internal investigation, to see what they have uncovered, to collect that information, and to use what they've collected in determining how to arrange and who to speak to in the investigation aspects of the case. Identify roadblocks to independent investigation, develop strategies to circumvent. It will never be simple or straightforward, but you have to be clear on again, all of the information that you gather prior to beginning your internal investigation has to be included. And if you see or perceive any roadblocks to the investigation, I think then it's going to be your responsibility to meet with the board and whoever else is responsible for that particular area and ensure that those roadblocks are removed. But again, it will never be straightforward. You may have to circumvent some items. Compromise on small issues with alternatives on the big ones. Yes, you should be able to compromise on process, but quite frankly, not on focus. If there's a meeting that if they're requesting that can be postponed, that's fine. But if the focus of the investigation should never be, the focus should be preserved in all cases. I'll turn it back over to Michael now, I believe.
No, actually, it's Bernie. I think I'm going to go ahead and talk
Bernie,
a little
I'm
bit
sorry.
about document collection here. And just very quickly, I think that it's quite obvious. I mean, when you're doing an investigation of any type, it's usually the documents that are going to be something that's one of the most important parts of the investigation. And the collection and review of those documents is an important component for folks to consider as they're putting together their overall strategy for the investigation. I've seen many cases where a single sort of long-forgotten document was found by a diligent reviewer, and that find changed the entire course of the investigation. So it's clear these are very important, and they're going to be very important in your response to any inquiry the government makes. There's certain aspects of this that, are about locking down your documents. So issuing a broad hold letter is something that counsel do on a regular basis to help ensure that there's no destruction of documents or the inadvertent removal of documents after the government has notified the company of an ongoing inquiry. There certainly is the ability of the IT team to freeze and collect the documents, and then there's going to be a situation where that information is going to have to be collected and then analyzed and reviewed. And there's a couple of different ways to do it. Now, on smaller investigations, oftentimes a company may have its own folks do it, and that may be appropriate based upon the advice of counsel. But in many cases where it's a larger scale investigation, there are third parties that are usually hired to come in and assist with the collection of the information and then the hosting of that information on some type of external document management system that allows the appropriate parties within the investigative team to review that information and to identify privileged documents, for example, to identify key documents, to collect documents as you prepare for witness interviews or things like that. So that information that's being collected, obviously it's computer hard drives, but it's also a lot of paper records as well. It's also email traffic, and so it's actually the PST files of individuals. So it can come from a variety of different sources. When you take a look at that, obviously counsel has to be involved in determining what documents are privileged, because you obviously have to protect those privileged documents, and that's usually a role that counsel, in fact, will play a big role in helping to oversee that whole process by which the privileged documents are actually collected and held aside from any production that's made. I do just want to mention real briefly, this concept of overseas document collection. It may not be relevant for a lot of companies out there, but there are companies out there that will have documents in a foreign jurisdiction. I would just suggest that, the sort of nature of how you deal, or the decisions about how you deal with those types of documents are ones where your outside counsel and your internal counsel can provide tremendous amounts of guidance. There are a lot of unique country-by-country restrictions regarding what can be collected, how it can be stored, what can be exported. There's obviously impacts about documents that you bring into the United States and what they might be subject to. And so I think that the most important component here is that everyone should know your domestic collections and your international collections may very well run with different criteria and different rules. And that's just the situation where counsel can help provide the guidance there, because quite frankly, the collecting documents in China is different than collecting documents in Paris. And it's different in collecting documents in Rome. It's anywhere you're going to be around the world, there's going to be unique situations that are governed by local law. And if you just race off and collect that information and bring it home because you say, well, it's my information, I can bring it, you're going to find yourself with a real risk of expanding the nature of your investigations, because you may have triggered something in a foreign land that you never intended to. So I think it's really important that this is an area where counsel can really provide some real guidance there. When you take a look at reviewing the documents, generally speaking, one of the ways that's, commonly done here is for counsel and other key members of the investigative team to come up with key search terms and key words that they think could be indicative of potentially inappropriate conduct. Now, there will be a lot of false positives in those situations, and I think that's readily acknowledged. But the concept here is that by collecting a set of key search terms and then applying those terms against the overall population of information that you've collected, you can then create a subset of documents which serve as a source for your further review. Now, there are going to be times when you're going to have to perform a complete review of all the documents associated with a certain individual. If the government's inquiry focuses on the activities of just one individual, you're probably going to have to do a deep dive into that individual's documents. But to the extent they're talking about overall business conduct over a wider range of groups or a wider range of jurisdictions, you're probably going to be in a situation where you at least start initially with this type of search focus, where you're actually pulling in a smaller subset of the population, and then you review those for red flags. And those red flags are, in essence, instances that suggest some type of potentially inappropriate conduct. And those red flag documents become the basis for conducting further investigative procedures. Maybe it's additional document review on those subjects. Maybe it's interviews with personnel. Whatever it is, the concept here is not that every red flag will ultimately generate an issue that needs to be discussed with the government. But instead, it's sort of highlighting documents that merit further consideration and further review by the investigations team so that you can become comfortable that, in fact, they are not reflective of some type of inappropriate conduct. When we take a look at sort of how the document review gets coordinated, this slide sort of breaks out the types of documents that might come up during the course of a government inquiry, whether it's documents provided from outside sources or in the last three, documents provided from internal sources. And I think the important thing here is, obviously you're going to drill down into each of these buckets and understand what they tell you about the conduct that's at issue here. So your accounting and financial records may tell you one thing, your interviews with employees may give you more information, and the business and transactional documents that you're reviewing, the emails, the correspondence, may provide you yet another source of information. But I think the important thing here is the ability to take information from one of these areas and to then search in the other areas to get more information to provide further clarification. So to the extent some type of potentially inappropriate conduct is described within emails, and there's a description of some type of financial transaction, one of the first things you can do is, with that information in hand, search the accounting and financial records to see whether or not the transactions described within the email actually flow through the company's books and records and actually occur. A lot of times we'll take information from a whistleblower report and look to see whether or not the whistleblower's allegations actually show up in the company's accounting books and records. Because in those situations where it doesn't, you may have a situation simply where you have an unsubstantiated allegation that a further review shows is in fact just a false allegation. So I think there's a lot that can be done in each of these individual ones, and I think a lot of times people get very focused on, well, what do the interviews tell me? And the interviews will tell you one thing, but it's important to compare what the interviews tell you and what the business and transactional documents tell you. And I think it's also important to see what the accounting and the financial records fill in for you. And by taking a look at all of these together and using them each with the other, so in the interviews using business documents as well as accounting records, but by doing that, you get a full picture of the situation that you have and the issue that you have, and you're in a position to have much more fulsome conversations with the government about what your investigation has shown. And so you're not in a situation where you're just saying the interviews showed X, but instead you're saying the interviews said this, and it was further corroborated by these transactional documents or these accounting records. So I think that while each one of these buckets is an important population of documents that you may look at within your internal investigation or within your response to a government inquiry, the reality is, I think, where you get the greatest help is the synergy that comes from comparing the various documents across the different populations. I'm now going to pass it back to Lou to talk a little bit more about sort of remediation. But let me quickly, though, before I do that, talk just quickly about a couple of document review issues. These are ones that may not be relevant to many of the investigations that you all will face, but I think they're important things to note. On foreign languages, there are internet translators out there that provide a good first step, but if you truly have documents that are in a foreign language, you may need experts in those languages to really understand and identify the subtleties in those languages. There's a lot of dialects, there's a lot of things there. So while you may use those internet translators for an initial review of the information, when you're down to the point where you have true key and crucial documents, you ought to be looking for some local language expertise as part of this. If you take a look at industry knowledge, you're going to hire people, or you're going to use people within your own resource group to review documents for you. And when you do that, you need to educate those people not just on the case, but on the industry in which you're working on and how transactions flow through your company. You want to do that so that your folks who are doing the document review have a much better understanding of what is happening in the documents that they're reading. There's a lot of times where emails can be very short and cryptic and can be for totally legitimate business purposes, but somebody who doesn't understand the industry or doesn't understand your business might misinterpret those documents. So having a good industry knowledge within your document review team is very important. The phased review of documents, I think, is something that's very important. A lot of times your initial review may be done at a very general level and may identify a variety of issues for which you then need to do a more focused dive into the documents for. I think doing that kind of phased review helps to control the costs associated with an investigation, but it also allows you to make sure that there's routine times when the whole review team can get together and make sure that everybody is on the same page before you progress on with additional types of focused reviews of any sort. Outsourcing the review in a lot of larger investigations, the review of documents is often outsourced to vendors who specialize in this type of review. The use of those vendors can have some real benefits on the way of costs, but you really have to make sure that you've put in the quality control procedures to make sure that all the documents are truly getting reviewed in the manner that they should. I think that responsibility to perform good quality control it's really crucial for the oversight team to be able to do that type of quality control with each of the document reviewers to make sure that you're getting a good outcome from that outsourced review. And then the final point, and I think that when you talk with the government, they'll tell you they want to hear this as well. If your review should identify things that are very good for the company, that show good conduct by company employees, that show people asking the right types of questions as they're faced with business challenges and things like that, you want to make sure that you capture that. You want to make sure that you show to the government that to the extent you have employees who are operating in an appropriate fashion with good intent and having good conduct, that doesn't get sort of overwhelmed by the inappropriate actions perhaps of one individual or one small group of individuals. So making sure to have set up mechanisms that you can collect information about good instances that you find is also something that's very important. Lou, I'm going to pass it back to you.
Well, thank you. I understand from the notes that I've been getting that we now have to go to the question and answer period.
Yeah, that's right. I mean, Lou, if you want to just take a minute to say what's in your closing slides, and then I'll ask Michael if you could pick a couple of the questions. Lou, what are people going to see on these slides?
Let me go very quickly, laying the groundwork for change. I'll go to the last item there. Make remediation a key priority so that government will give meaningful credit and public perception will improve. Absolutely critical. I've been dealing with many insurers, quite frankly, in the last couple of years, where we've had to put together against state regulation corrective action plans that included most of the items that were discussed in this presentation in a way that the government, the regulators would understand that the things in the past no longer exist. We've corrected them. So that's going to be very important when you lay the groundwork with the regulators or state or federal government.
Somebody asked if in-house counsel should be present or be allowed to be present during an interview. This is an interview of, let's say, conducted by outside counsel and maybe possibly by the government, but should the in-house counsel be present? I don't know, Lou, if you have any feelings with regard to that in terms of having in-house counsel present when their employees are interviewed.
Well, I would have left that to the experts, quite frankly. In those kinds of cases where that question does come up, I believe that the general counsel should be making those decisions based on the person being interviewed and who's doing the interview.
Yeah. I think there also is a question in terms of outside counsel is doing the interview. They're supposed to be independent and gathering the facts. And what you don't want to have is a situation, it depends on the relationships, but you don't want to have a situation where in-house counsel, for example, is viewed as intimidating or influencing the witness in their answers to the questions. One other issue in a related front, and one of the questions that came up is the issue of whether or not in-house counsel should meet with the government with outside counsel. And I always think it's good to have, assuming the in-house counsel is not the subject of any type of investigation, I do think it's good to have somebody present from the company to provide a face for the company in terms of that. One last question that came up, and please send us any questions. We're sort of monitoring it right now. The other issue that comes up, have any whistleblowers who provided false information ever been prosecuted for false statements or anything like that? The answer is a resounding no, because if that did happen, the government doesn't want to, they'd rather cull through what are, a lot of complaints, and they don't want to sort of deter people from doing, providing information like that. Then another question that's come up has to do with when does, for example, the board, and when do you see outside counsel being brought in? How much information does the board have to have before they make that step to going to outside counsel? And I don't know, Bernie, you've been in these positions before in terms of helping companies navigate through this issue. Where do you see the line coming with regard to when outside counsel should come in?
Well, for me, it really is a situation as to the scope and size of the investigation. I obviously always defer to counsel, Michael, as to what's the most appropriate thing there. But I think the situations that I've seen in my own practice is that as a case becomes much more significant and a significant exposure to the company, they are quick to bring in outside counsel. In situations where they feel the government may just simply be looking to them as a third party and not actually as an individual or a group that have actually had inappropriate conduct, many times the company has kept that in-house and use their own resources then. But it really does come down to a decision by the general counsel along with the board and all the interested parties within the company about what they're most comfortable with.
One other question that came in is that most of our commentary has assumed that our client is not a bad actor, and we've discussed walling off subjects of the investigation, and then asking when do we seek separate representation for employees or managers. And that's a very interesting question. First off, I don't mean, and I don't think any of us meant to suggest that there was nothing that occurred that was bad. If anything, what we're suggesting is a way to approach a situation where you have a problem, where something did occur, obviously not the whistleblower story where it turns out to be fabricated, but you have a serious nightmare scenario, and you're trying to minimize the damage to the company and the repercussions. These are steps that we're talking about in terms of minimizing those damages. You can also do an internal investigation and find out there was no problem and then come back and argue that to the government. But the point about separate representation is a very difficult issue because at some point people and we didn't get a chance to get into the upjohn warnings that are given to employees before the interview occurs or at the beginning of the interview. But there are situations where there is a conflict between the company's representation of an individual or not, or just that the individual has a conflict and the company cannot represent the individual to the extent that the company is representing the entity itself, that a counsel is representing the entity itself. So you run into situations where you do have to seek outside counsel for an employee, and then there are issues as to whether or not the legal fees are paid by the corporation, and there are indemnification statutes that come into play as well.
Okay, we're gonna have to end it there. So, Michael, Bernie, and Lou, thank you very much for all of your preparation and insights on this call. We strongly request that the attendees follow the link for the survey. Again, Lexis wants to hear your feedback. Many of you have requested the materials. This full presentation will be available on demand for viewing again, and we'll make sure that the materials are available. We had probably a record number of questions for this. Lexis also publishes the LexisNexis Corporate Counsel Advisory, which is a complimentary newsletter that goes out to corporate counsel and legal departments across the country. They also but it can go to, anyone can register for it, so if state and local government are interested as well, you can get that. We're going to be covering this seminar or this webinar for that, and we're going to incorporate in the article answers to many of the questions that we see that we have been submitted today. Also, I believe we can on the slides we have the contact information for the speakers. So if you are interested in reaching out to them directly, there's their contact information. So on behalf of Lexis, thanks everyone for attending, and that wraps up this webinar. Thank you and have a great day.
And again, this does conclude today's Government Investigations Best Practices for Responding to Federal Probes conference call. We thank you again for your participation.